Hello and welcome to this first part on a recognized lecture about the dual challenge from artificial intelligence and cognitive science, giving a framework for analysis. My name is Antonia Waltermann. I'm an assistant professor at Maastricht University in the Netherlands. And in this lecture, what I want to do is to make the claim that developments in artificial intelligence and insights about human cognition that are coming from the cognitive sciences challenge the law. Both of these kinds of developments or insights challenge the law in comparable ways, but at the same time, there are some distinctions that we can make with regards to the ways in which they do challenge the law. So what I want to do in this lecture is to, on the one hand, provide a conceptual or analytical framework for understanding and for situating these challenges, and on the other hand, also look at some possible responses to these challenges. The first part of this lecture, which is what you're currently watching, will predominantly focus on the conceptual framework, whereas the second part of the lecture will then turn to possible responses to these challenges. But what is it that I'm talking about when I say that there are challenges to the law from the cognitive sciences and artificial intelligence? One example of what it is that I'm talking about is that in 2014, the criminal law in the Netherlands that is applicable to young adults or adolescents was changed, or rather a new criminal law was introduced that changed under which circumstances, or rather to which age group, provisions of the juvenile or adolescent criminal law could be applied. The rationale of introducing this new law and extending the group to which the juvenile criminal law could be applied was that there were recent findings in neuroscience and developmental psychology, which suggest that even though someone has turned 18 and thereby reached the official age of majority, so legally speaking, they are considered an adult, they are still going through important stages of brain development, including their emotional, social, moral, and intellectual development. And the idea there was that it may not be suitable, or it may not be fair, correct, to then hold these individuals criminally liable in the same way that you would someone with a fully developed brain. So in the Netherlands, these insights from neuroscience and developmental psychology actually had an impact on how the criminal law is applied to young offenders. Another example is that there is research that shows that when someone is acting under coercion, which may be the case, for example, if we're talking about international criminal law, which may be the case generally speaking when it comes to acts of war, but which may also be the case in other cases of coercion, so something less, say, drastic, coercion in contract law, for example, that this actually modifies the sense of being responsible for the outcome of one's actions. So that when you are under coercion, there's a greater distance when you're being coerced, there's a greater distance between how we tend to link our actions, our decisions, and the outcomes. Given that our laws generally are rules that we have to guide our conduct, and that have as their aim, I would say, to guide or to influence our behavior in some way, shape, or form, laws should take these sorts of insights into account, is also what these authors would suggest, and I do agree with them on that. So also here, the idea is that these insights challenge our existing legal practices in some way, and that the law should somehow reckon with these insights, should somehow take them on board, should somehow be adapted to these insights in some way, shape, or form. Both of the last two examples that I've given were about human cognition and about human behavior. Here we have an example coming from the field of AI, holding that there may be a possibility that a machine that argues on the basis of deductive rules, facts, and categories can actually reach the level of complexity of human legal reasoning and perhaps even replacing it. This is particularly with regards to the context of legal decision making and human judges. And we see that link come back in this excerpt of the text, saying that this also raises some questions about human cognition, in the sense that we are not actually sure that the human judge argues only by deductive categories, or, for example, what the role is of emotion in taking a decision, taking a legal decision. And this could go either way, right? It could be that a lack of emotion leads to more fair judgments, that there's fewer biases, that there's, for example, no discrimination. But it could equally be that a lack of emotion in taking decisions would lead to unfair judgments, or to judgments that are felt to be unfair, if that is a different thing from it being unfair in the first place. Another example is the following, whereby the author holds that also in the context of judges making judicial decisions and the use of AI in this scenario, there is the problem that a lot of technology at this time is considered to be essentially a black box, that given its complexity, given the lack of transparency in the development, but also in how an artificial intelligence system might come to a decision, we don't really understand what is going on in the system, and that this is a problem, that there's a lack of transparency, that there's a lack of explainability, and that this actually undermines, for example, concepts such as the rule of law. So that this would be something that is unfair, and that we should not, for this reason, use this sort of technology in legal decision making. So a different kind of argument, one saying, well, actually, we really shouldn't implement this. So a different approach of how developments in AI, or rather a different approach to how developments in AI could impact or not impact the law. I find this one particularly interesting also because it presupposes implicitly that we do know these things for a human judge, so that a human judge is more transparent, is more fair, and can better explain their actions, so that the human judge is not a black box, essentially. So these are just some examples of possible challenges or possible approaches to some challenges coming from developments in artificial intelligence. Should we use AI to support judges? Should we replace human judges with AI? Can AI reason in the same way that a human judge can? And should it reason in the same way that a human judge can? But equally, what do we actually know about human decision makers, about how they function, and in how far should the law not take into account how human cognition and human decision making work, given that there are continuously new insights about us coming from the cognitive sciences. Now, in developing the analytical framework that I want to suggest can help us figure out what is actually going on in some of these challenges, and can help us situate some of these challenges in a bigger picture, one distinction is quite relevant, and that is the distinction between internal and external challenges, or the distinction between justifications of a practice or justifications within a practice. The distinction between internal and external challenges I have personally taken from Anurag Makur. The distinction of justifications often within a practice was developed by Rawls. But we see this distinction come back also in many other contexts. I have provided here a picture of a gentleman walking in the rain. I have done so because one example that I like to use to explain this difference of justifications of a practice or justifications within a practice of external and internal perspectives is the example of a rain dance. We can look at the practice of rain dancing and we might challenge it from essentially from our perspective, from outside of the practice, by saying that rain dancing is very much unlikely to lead to actual changes in the weather. That would be a challenge that is external to the practice itself. And we would essentially be asking, why is the practice as such justified? So we would be asking for a justification of the practice by questioning the possible justification of that practice as influencing the weather. At the same time, we could take a different approach and, for example, critique someone's step pattern. So in that particular case, we would not be taking an external approach, but rather we would be taking an internal approach. We would accept the practice as is, but we would challenge a particular instantiation of that practice as not following the correct pattern, for example. This distinction of internal or external challenges or justifications or questions, demands for justifications, can essentially be transferred to just about any social practice that we have, including the law. So if we take our current legal practice or current legal practices, then we can take that as a practice, and we can then say, okay, there are internal challenges and there are external challenges to this practice. In this connection, Anurag Makur has developed 4 different kinds of questions. There are some internal questions or internal challenges and some external challenges. When we're looking at the applications challenge, which is internal, then what we're essentially saying is that there is a challenge to how our legal conceptions are applied. So how do we apply certain legal concepts, for example? And I will be giving examples of all of this in a moment. If we're talking about a slightly more demanding challenge, but still one that is internal, then the question becomes, okay, but what are the criteria for application? Or what are the criteria, what is the content of our conceptions of legal concepts? And should those not change? Both of these are internal challenges because we're within the practice of law. We're not questioning the practice as such. We're not challenging the practice as such, but we are challenging or we are questioning, we're addressing aspects of the practice. On the flip side, if we look at external challenges, again, here we can distinguish between 2 different kinds. On the one hand, we can say that there are some challenges to essentially our fundamental presupposition. So everything that underlies the practice in the first place. This is a very, very far-reaching kind of challenge because it essentially questions the practice as such. Should we have this practice? Is it a good practice? Do the presuppositions of this practice hold? Another approach in this connection would be to challenge the practice by taking the aims of the practice for granted, but showing that given the way the practice is currently set up, it frustrates its own purposes. So it does not achieve what the practice itself wants to achieve. This is not quite going as far as the previous challenge because we are taking for granted, or at least we are not challenging the aims of the practice, but we're essentially showing that the practice is incapable of achieving its own aims. So to give some examples of that, let's again start with the question of application. So the bottom left quadrant. Say that, and this is something that has in a limited number of cases been shown, a brain tumor causes pedophilia. Should then offenders with such a tumor fall under diminished capacity? Should they receive a reduced sentence? So here we're asking whether conceptions that we have and the criteria for their application, whether a particular group that we hadn't necessarily considered before, namely offenders with a particular sort of tumor, whether they meet those criteria. This is very much internal to the practice of law. We're not questioning the practice in any way, shape, or form. What we are doing is we're looking at whether a particular group of individuals, of entities, fulfill existing requirements of existing criteria for how we apply our legal concepts. We're not even challenging the concepts as such. Essentially, the law remains as it is. Existing legal rules remain as they are, but now there's an additional group of people, namely offenders with a particular type of brain tumor, to whom a certain rule also applies. If we then go one step further, we move to the top left quadrant. We might have the question of whether current liability regimes should be extended to cover actions of artificially intelligent agents. Here then we would be looking at making larger in the case of extension, but we could also imagine a scenario where we're actually making smaller the criteria for when particular concepts of law apply. We will, by the way, in the third lecture of this particular lecture series, have a closer look at this question. So stay tuned for that. So those are two different types of internal challenges, or two examples of two different types of internal challenges. If we look at the external challenges, let's again start at the bottom. Here's a quote from two authors, Alsace and Sapolsky, who argue that the law reaches conclusions that undermine human thriving. Now, admittedly, they were implicitly presupposed, but I think that's a relatively fair assumption to make, or at least one that many of us might be inclined to share, that the purpose of the law is to further human thriving, that ideally law should contribute to human flourishing rather than undermine it. And what they are saying is, okay, if we take that goal, law doesn't actually reach it. Why does it not reach it? Because it relies on a misconception of what it means to be human. If we go a step further, then we might see there are some arguments that hold, and again, we will have another look at this also in the following lectures, that artificial intelligence cannot be legally responsible because, for example, they lack free will. But we may have good reasons to assume that human beings don't have free will, or at least not the type of free will that is required either. So here we're questioning a presupposition that the law makes and saying, look, that presupposition is flawed. So this doesn't actually work out. In all of this, we can further distinguish two different things. We can distinguish whether the challenge concerns human cognition or whether the challenge concerns artificial cognition, so whether it's about artificial intelligence or about human intelligence. This is not a necessary distinction to make, but it can be helpful, especially because I think many people do make that distinction. We can furthermore distinguish between challenges to the concepts that we use within legal reasoning, but we can also look at challenges that are about our legal reasoning practices as such, that are about how we reason. If we make those distinctions, then we get this full framework with 4 quadrants that, again, each individually have 4 quadrants. That's a lot of distinctions. If all of this was a little bit too quick, there is also a paper where you can read all of it back. For now, let that sink in and take a short break.